Well, my name is Julietta, and I'm so super glad to be here. Actually, I just want to take my time first to congratulate everybody because those were such an amazing presentation, and they do give testimony of how much they've enjoyed the course and they've been learning. Thank you so much, Karen, and everybody for your work. We could not be here without Ellen, without Cheryl. Thank you, guys. So please, let's just give everybody an applause right now, please. You learned it. And well, as all of my brilliant students just really stated, we've learned a lot from this 1 week course. Actually, it was even more than we can chew because it was a lot of information, a new culture, a new system. And I wanted to address it in a way that we could maybe take something back home and maybe apply it to our legal system. So what I did was some sort of a comparative analysis between the US legal system and the civil law, Mexican civil law, and see if this whole learning applies to how we are doing human rights law. Because back in Mexico, we do have human rights law, and it's a whole branch that we are actually developing and that it's growing. And it literally blew my mind that you do not have anything about it, right? But still, we went to Professor Brem's class on evidentiary law, and we heard the rules of evidence, and we noticed that there was some sort of protection to the victim. So there is some sort of human rights law within your laws, but not literal. So this was interesting to me. So I really do believe that the subject that I chose was international, this Professor Cardenas class. So what I wanted to do was to see if we, taking human rights law, we were kind of applying your legal system instead of our legal system. That's what I was wondering about. So first of all, I did this exact comparison between both systems, as Roy just presented. So what we can see is that we definitely saw the differences between the US common law system with all of this case citing that Michelle was complaining about and telling me so weird. And then we have our Mexican legal system where we need to know what the law is and to copy paste our whole code so that we feel sure it's being applied. So what we are looking at is these, Professor Cardenas' words, weird pyramid concept of the law, right? So this was a really surprising thing to hear from him that you do not study Kelsen here. Hans Kelsen and the hierarchy of the law, of the sources. And we were like, what? You don't know Kelsen? What do you study? And he talked about someone named Austin. I have to read, of course. But this was new to us. It was like, then how do you decide which case is more important or not? And that's the whole difference here, right? Mm-hmm. Case citing, it's about applying, doing analogies, and trying to create something for these exact problem, facts, and case. And we just try to apply the rules always by using our codes just because they are the most important ones in our legal system, right? So that's the whole point. So what I did here was we do have also this hierarchy and structure in our legal system. We do have that, but we did not understand how would you defend a human rights problem here in the US. And Professor Brem told us that you need to kind of attract the case to the federal system, the Supreme Court, to go and actually argue a constitutional violation and to see if they care to get justice. So that was pretty weird to us because we do have what's called the amparo, this judicial resource that we can go and activate our courts for any sort of human rights violation at all times. During a trial, at the end of the trial, with the resolution, and we can just go and say, hey, we need help. So that was really different for us, and I was looking at this. Well, then what we need to look at is that human rights law has all of its inspiration from the international system. So we're just pulling these international treaties into our internal law. We are adopting these according to the Vienna Treaty and the law of the treaties. And what we're doing is that we are inserting into our pyramid this international law hierarchy. So it's kind of weird, and we do have trouble about that because our Supreme Justice, they've said that what's more important at all times is the Constitution, so that if in any case the Constitution contradicts whatever we've signed and ratified on the international system, we don't care about that, even though we signed it, and we are going to apply our exceptions in the Constitution. So that's what we are having. Oh, thank you. So that's what we are looking at. So what I'm trying to tell you guys is that when we go to the international human rights courts to go and ask for help because our country has not covered our human rights, we have to go and cite cases of those courts. So we kind of use your IRAC method. It was like, do we use that in that court? Because the sentencing of those tribunals are designed for the whole region. So they kind of look like yours. They're not exactly the same, but that's what I wanted to show you guys and apply and see if we can see that, okay? So the IRAC method that Michelle brilliantly explained, we have it here, right? The issue, the rule, the analysis, the conclusion. So what we're going to look at a sentence of the Inter-American Human Rights Court here. And what I want you guys to see, this is a sentence that in which they actually sanctioned the Mexican government for their role on the femicides of a lot of women, a ton of women at Chihuahua. This is a famous case. We also know it as Campo Algodonero. That's a place in Chihuahua where a lot of women were being killed just because they're women. And this case went to the court. And if we see the structure of the sentence of the Inter-American Human Rights Court, we'll always find on the second paragraph number 2, what the issue is here. So if you can see here, the application relates to the state's alleged international responsibility for the disappearance and subsequent death of Miss Claudia blah blah blah, whose bodies were found in a cotton field in Ciudad Juarez on November 6th, blah blah. So they state the issue, whether the state is responsible or not, and they mix it with a little bit of the context and the facts. But that's the I on the IRAC, and that's paragraph number 2. So I really do think we kind of follow this structure. Then, if you continue reading the case, you'll find they start, that goes to our legal system, they start describing what happened in like the judiciary history that the case been through, and they describe that, and they describe what are the arguments of each of the parts. The victim, the Inter-American Commission, which is another party here, and the state, what the state said. So they start describing that, and then they enter to the application of the rule. They enter the rule, they state what the rule is in the Inter-American Human Rights system, and the application of that in the same space. So they analyze, for example, I'm going to show you. Vamos, bajemos. This is proceeding before the court, what I'm telling you. And then we're going to go to one of the issues being decided, the substantive matter. You see how long it is? Still long, but it follows the structure. That's what I'm trying to prove here. But it is not.
161 pages.
I don't care, it's a good one. Let me show you. I love it. Okay, so for example, here, this chapter, violence and discrimination against women in the case, right? So they're trying to argue, to decide whether it was there was a violation to Articles 4, 5, 7, blah, blah, blah. So what they do here, they copy the articles, of course. They start analyzing whether what everybody said and what happened. So let me show you. que en inglés me cuesta, no lo encuentro. No, estamos pasando las partes. Okay, for example, gender-based violence. No? According to the representatives, the state, they present what each of the parts said, and then, no, pero aquí está, the state, que no sé, no puedo. And then you have the court notes that. So they do follow this structure. They, according to this, and then the bakers or whoever, the court, blah. So they keep changing that, and you can find that in all of the on the paragraphs. And then you know what the court is actually what's the holding of the court. So you kind of do see that, and then you would find all of these citations in the bottom. Of course, it's hard to read, but you'll find citations of all of the previous cases they've reviewed on these same situations. So let me show you one of those, because they are citing here UN authorities. But let me show you cases. So, for example, let me see. Let me do this. Probably easier. Okay, for example, case of the street children, blah blah blah, supranote, blah. That's a complicated citing as well. That's yours. That's not that easy to realize. But we can see they refer us to previous cases of the court that we have to see, because what they are doing is they're respecting their own holding on the matter, and then they can decide to change it, but they will refer us to the previous cases. So there are a ton. This is a kind of not that new case, but there the jurisprudence on this keeps growing, so we need to know the previous cases and start studying the precedents to ask the court to apply them. So it's kind of a mixture of what we can see on our civil system and what you guys have on the U.S. Legal system. So that's why the proposal here is for us to start thinking IRAC. That's a call to action. Call to action: start thinking IRAC, start structuring like that, because I think we could evolve towards that, and it would be really useful for our studies back in Mexico. So actually the new program of law that we are designing is based on case method, only case method only. So all of the professors are deciding to choose on the basis of cases, iconical cases, and the study of that, in order to be applying the theory that we normally do it the other way around. We study the theory, and oh yeah, there's been cases. But now we're doing it the other way around, just as you guys, so that we're gonna get there. I wouldn't say it's an evolution necessary, because I don't feel like we're getting apart from that formal part that Daniela loves. I don't think we're doing that. It's a way of culture in Mexico. We are kind of respectful, and so we I don't think we're losing that. Yeah, we're polite. I don't think we're losing that. Not that you are not that, but that was easy.
No, the writing, no. I think the writing.
The writing.
Is very polite.
Exactly.
Not the person.
Because it comes from this thought that, as Michelle said, that the judges are superior. He or she is wiser, or them, and of course we're trying to respect that knowledge, and so it's a lot of structural ideas. So just to close this presentation, the presentation, no, debe ser acá abajo, en el edge, en el símbolo edge. Okay, thank you, Michelle. So what I really do feel it's important, and we can take back home, is that we need to be sure to have a really clear idea of the legal traditions that exist, so that we can identify what's what. Because Professor Cardenas introduced us to a concept of transnational law, and each day we are, as a global community, I think we're moving towards that. We are having more and more dialogue between our legal systems for commercial reasons or human rights reasons or whatever, and we're starting to have I don't know, like puzzle pieces together between our legal systems. So I really do think that we have to study our legal traditions, see the points of connection so that we can start providing solutions, transnational lawyers, binational lawyers, international lawyers, and of course, what I feel is that there are strengths in both sides as well as what's the other word? Weaknesses. But of course, I really do think that if we focus on those strengths, we can do something great together. So he told us about losing the pyramid schematic in our minds and think more of a net that connects everything, and that's a lot more transversal, horizontal. So that makes sense to me, and I really do think we can move forward to that, and that's the conclusion I have for you today. Thank you, guys.